This video is very important. I need you all to pay attention to that video because I'm going to mention a couple of things that you need to consider before you start drafting your pleadings. And one of the very first things that you need to consider is, let's say, if you basically dealing with an issue, you're dealing with multiple issues that actually are actually rise from the same facts that have not really that not really quite, which the damages actually do not flow from this kind of fact, but where the damages flow from different kind of set of facts, which all flow from the same sort of facts. You need to know whether you're going to plead those facts in one cause of action, or you're gonna have to leave them out because of possibly perplexing and complicating the action. Now, with due to the modern interpretation of res judicata, you're gonna have to know that if you miss any facts, or if you miss any action, any sort of cause of action out from the facts that you plead and that you're basing a certain claim on. So if you miss basically a certain set of facts which are different and give rise to a different set of damages, then you may never ever be able again to plead these kinds of facts in another action, because the modern interpretation of res judicata will be stopping you, right? So that's one very, very important thing to consider. So another issue, another thing that you need to consider before you start drafting is if you got any preliminary objections. And you'll ask me why I need to consider that, because if you got any preliminary objections, then it's the best time to raise them is when you to raise them in your pleading. The first pleading, for example, could be your defense. When you want to challenge the jurisdiction of the court, you can do that. You should do that in your defense, and you should know if you got any preliminary objections. You should know that you should plead them. You should mention them before anything else. So before you start, putting a disclaiming paragraph of denying each and every paragraph in the statement of claim, unless otherwise admitted therein, then before that you're gonna have to plead the preliminary objections, and this is because of the necessity to separate and to divide the objections from the rest of the pleading. The objections, you need to mention them, and you need to also plead them without prejudice, because if you plead them without prejudice, you basically if some of the objections contradict your main defense, then you're gonna have a problem, because let's say if you challenge the jurisdiction of the court but you do not mention that you're doing it without prejudice of your defense, then if then you might just risk the possibility or even your preliminary objection not passing as valid, because remember, you can challenge the jurisdiction of the court on one hand, and on the other hand just laying out a defense. So, but if you just mention without prejudice, that means that the objection can stand on its own, and then it's fine, because you're not going to be risking having your objection being kind of overridden by the fact that you gave in to the jurisdiction of the court at the same time by submitting a defense. Another thing that I want you to to know is when you how you're going to start drafting your pleading. So if you start as a plaintiff with a statement of claim, and I'm mostly referring to the jurisdiction of England and Wales, and certain other common law countries when I'm talking about pleadings in this video. You need to know how you're going to start drafting your pleading, what you're going to mention in the first paragraph. Now, are you going to start from from what kind of events? Is time important? Are you going to have to start with the event that one of the events that basically started way before anything else just happened, and then finally, as you develop, just arrive at the event that basically triggered the cause of action, that basically brought the plaintiff into connection with a cause of action, with this basically with the adversity that it faced. You're gonna have to plead, or you're gonna have to plead, for example, the event that occurred before the event that set things in motion for the plaintiff. For example, the purchase of certain stuff, or from supermarket, or even the like visiting a restaurant and getting food poisoned, or anything of this sort. Are you gonna have to, because a certain other event was proceeding in time, are you gonna have to choose that event over the event that set things in motion? And what makes sense here is that like, even if time is key and time is really important, I'm gonna come down to that in a second. When you first start pleading, you have to consider what really makes sense for your pleading. You're gonna have to take an interview, and usually you'll start with what actually set things in motion. So if it was a misrepresentation that induced the plaintiff to enter into a contract, that's what you're gonna do, regardless of the fact that there were orders given like a couple of days before that, that predate that misrepresentation. So you're gonna have to see how this affects your story, and you start by you start by the event that is connected to the to how things basically started, to the start. Now, another thing I wanted to mention, and this concerns matters of incorporation. So I'm basically joining, pleading, drafting, things to consider, and matters of incorporation in the same video. So that's basically quite generous of me. You should be feeling quite privileged. When you start drafting the pleading, as I said, it's you'll there may be certain facts, maybe they may be a certain set of facts that gives rise to identical cause of action, especially when we have multiple defendants. And this identical cause of action may have, when they have occurred at the same time. And when I'm saying the same time, could be like the same day, the same hour, or it could be they could be basically some time further apart. What really needs to be attended to is when there's like these two identical calls of action, and even though there are they're not close by in time, and they're basically kind of apart, far apart in time. Um, if and only if the time is not of the essence, which means basically if the time does not affect the the chain of transactions, like how your story escalated, how it develops, right? Um, then you can plead this 2 or 3 cause of action um, back to back, and this is going to be a lot easier for you because you're going to be incorporating stuff which which raise like similar or same allegations, given the fact that they're identical calls of action, only with the difference that they just concern different defendants. So you can do that. However, if they are if they are far apart in time, then another intervening cause of action basically intervenes. Then you're gonna have to plead that intervening cause of action, even though it is, regardless of the fact that it's a different cause of action. So you're gonna have to again examine what kind of effect, how they affect your story, how they affect the order of events, because the order of events is basically a key rule. It's a principal rule in pleading and in law. When you need to plead your stuff. You need to plead your story sequentially. You need to plead them so that in an order so that it makes sense. And when the law is concerned, the order of events makes a lot of sense because it gives, first of all, it gives a proper notice to your opposite party and to the court. The court knows what it deals with and can make all the difference as to whether or not liability exists, right? So if you're gonna do the trick with the incorporation, and this is just because it's gonna be easy for you to incorporate with back-to-back identical cause of actions than than if you had to, if they were like further apart. You're gonna have to scroll back and forth the pleading. If you're gonna do that, you're gonna have to see whether these identical cause of actions are, if they are far apart and kind of happen like at different times, if they sort of affect your story. Because if they do, then you're gonna have to, regardless of the fact that they're identical and they happened on the same date, let's say, if there's an intervening cause of action, intervening claim, you're gonna have to squeeze that in so your story basically makes sense. So time is of the essence when you draft your pleading. Now, thanks very much, all of you, and please subscribe to my channel for more videos like that. And this information is should not be considered as legal advice. It's purely informational. Feel free to do your own research. Have a good day.